For reaction from the Office of the Public Protector, we're joined on the line by Senior Manager at Legal Services in that office, Alfred Mhlongo. Alfred, thank you so much for joining us. We believe you were there this morning when the judge handed down that ruling. The immediate reaction from your office, please.
Yes, thank you so much for having me on your show. Greetings to you and your viewers. So we take note of the judgment that was handed down today. We will obviously have to consider the judgment and give it a close reading to explore all of the available options that will be available to us before we can meaningfully be placed in a position to chart a way forward and take the appropriate action. In the meanwhile, we take note of the judgment, and considering the legal submissions that were made in writing and our arguments that were made orally by our lead counsel in the matter, we would have expected a different outcome.
Now, we just had the reaction from the EFF, not mincing their words. They've already said that they will be appealing this judgment. Mr. Ndlozi there saying there is no moment where the judge explains exceptional circumstances in the case for you to suspend the power of the public protector and for you to suspend remedial action. Can you at least say whether you agree with his statement?
Our considered view has always been that the President owes the Office of the Public Protector an indispensable constitutional obligation for him to promote and protect the independence and the integrity of the Office of the Public Protector. His failure or his refusal to implement the Public Protector's remedial action at its barest minimum constitutes, in our view, a abrogation or a breach of his constitutional obligations in that regard. It's premature for us at this stage to formulate an opinion until such time as we've been furnished with a written copy of the judge's reasons for her decision, as well as the judgment for us to, on close inspection, fine-comb through the legal issues and the pronouncements and the factual and legal pronouncements upon which the judge has made her decision, and that would form the basis of what our course of action will be.
So your office obviously feels hard done by this decision, but the judge did say that the President, she felt, acted rationally or reasonably, some people would say. Some of the reaction coming through saying that that's fair, that only makes sense for him to await the outcome of that judicial review by Pravin Gordhan. You seem to think otherwise.
So we have taken the view that the relief which was being sought by the President in the matter was, and our counsel spends quite a bit of time in court addressing this, the fact that the relief that was being sought by the President is not provided for in our law. It's a legal anomaly for the President to approach the court for an order, essentially interdicting himself from executing his constitutional obligations. We found that the relief that he was seeking was self-contradictory. He has been granted an order to the effect that he has complied with the Public Protector's remedial action, yet by the same token, part of the relief that he was seeking, which has been granted, is for him to suspend compliance pending the outcome of Minister Gordhan's application. That, in our view, and to use the judge's words, is what we consider mind-boggling.
Now, this is another cost order that's been handed down involving a court case involving the public protector. It's turned out to be quite an expensive few months for the public protector, both for the office and her in her personal capacity. Do you have an understanding from this judgment whether this cost order is for your office itself or for Busisiwe Mkhwebane in her personal capacity?
So on our reading and, having been present at court this morning, the cost order that was made is against the Office of the Public Protector together with the Economic Freedom Fighters. It's not against the Public Protector in her personal capacity. None of the parties sought that as relief. And in that regard, with the recent judgments and the recent developments from the judiciary, I think we must be quite categoric as the Office of the Public Protector in stating that each of these matters and the decision whether the Public Protector will oppose the urgent interdict that is being sought is not a decision that is taken randomly or haphazardly. It is a decision that is considered after the public protector has solicited and obtained external, independent and objective legal advice, including opinion from senior counsel. In this matter, we had 2 senior counsels and the junior on brief, and the decision to oppose was taken after, it was a well-considered decision after considering the value judgment and in line with the public protector's constitutional mandate.
Okay, we'll leave it there. Thank you so much for your availability. That's the Senior Manager at Legal Services at the Public Protector, Alfred Mhlongo, on the line giving us reaction to that top story of ours.